All right. Well, we are at the top of the hour here, and we have a full panel to get through today. So let me be the first to welcome you. My name is Joey Gartner. I'm director of the American Bar Association's Center for Innovation and the staff counsel for our task force on law and artificial intelligence. Today, we have a great event for you, which is entitled Unraveling AI's Impact on Intellectual Property, Expert Perspectives. Today's event is brought to you by the AI Task Force on Law and Artificial Intelligence and its working group on AI risk management. Our panelists will be attempting to answer audience questions live today, so please post your questions into the Q&A function below. Our panel will address as many questions as time allows, and we'll be answering both live during the event and well as at the Q&A at the end of the session. Additionally, there will be live transcription of today's webinar. Today's webinar will also be available on the ABA Task Force on Law and Artificial Intelligence website starting on Monday, April 29th. So we encourage you, if you are unable to attend live, to watch it there. The views of our panelists today are their own and do not reflect their employers or the ABA. Comments made by our panelists are not made on behalf of the ABA and have not been pre-approved by the Board of Governors or the House of Delegates. Moderating today's conversation will be Lindsay Edelstein. Lindsay is an attorney at Mitchell, Silberg and Knapp, and where she works in the Intellectual Property and Entertainment Litigation Practice Group. Lindsay represents many leading businesses and individuals in the music, publishing, film, fashion, travel, hospitality, media, and television industries, as well as emerging and established technology businesses. Lindsay has significant experience with litigation in both state and federal court across the country, with a concentration on copyright, trademark, and contract and commercial disputes. She is currently a Copyright Society trustee, the chair of the New York City Bar Association's Copyright and Literary Property Committee through the end of 2025, as well as a member of the International Trademark Association and the Media Law Resource Center. Lindsay, I'm going to get out of your way and leave it to you. Let's have a great conversation.
Thank you, Joey. And I wanted to welcome our panelists to join as well. Hi, everyone. So yes, thank you for the introduction, Joey, and for all of your help in putting together this panel. I'm thrilled to be here with this excellent group of panelists to, as the title suggests, unravel AI's impact on intellectual property. Given all the complexities and uncertainties surrounding AI and copyright law, we recognize that that's a tall order, but we're going to do our best. Specifically, this panel will discuss pending cases in the US, the role played by the WGA and SAG-AFTRA and others in negotiating terms relating to AI and intellectual property. And we'll also explore standards and regulations in the UK and EU that could prove instructive. This is a 90-minute webinar, so we'll probably leave 15 minutes or so at the end for questions. But please feel free to type those into the Q&A function, and we'll answer them when we can. And with that, I'll introduce the members of our esteemed panel. First, we have Claudia Ray, who's a partner at Kirkland & Ellis's New York office and a member of the firm's IP litigation department. She advises clients on broad-ranging IP issues, including those related to copyright and artificial intelligence. She recently authored an article for the New York Law Journal about the groundbreaking sanctions order in the SDNY against an attorney who admitted to using fake citations generated by ChatGPT in a court filing. And the article was entitled, "If You Think It Thinks, Think Again," which is a good play on words. We also have Ekta Oza, who's a managing associate at Linklaters in the firm's technology, media, and telecommunications and IP group, and is a qualified attorney in the UK. She primarily focuses on technology law and commercial contracts, complex data regulatory work, including in the context of AI, and digital services regulation issues. She recently co-authored an article for NASDAQ entitled "ChatGPT, Bing and Bard, What Businesses Need to Be Thinking About." And she'll be bringing a UK and EU perspective to our discussions. And last but not least, we have Louise Nemshoff, a Los Angeles-based IP and entertainment law attorney. She represents a wide variety of parties in both domestic and international transactions in film, television, publishing, animation, digital media, including mobile content and transmedia. She also mediates entertainment industry and intellectual property disputes, and is an adjunct professor at Southwestern Law School, where she teaches a course in video game law. So we have a very qualified panel. And given all that background, and since our panelists have such diverse practices, we thought it would be good to start the discussion by just asking everybody, what general AI-related questions or concerns have each of you been hearing the most from your clients? And Claudia, I guess you could start us off.
Sure. It's a range, and it's quite interesting because a lot of it is coming out of their own industry. Sometimes it comes from clients who don't have an immediate application for AI, but they feel like they need to know about it. But we get questions around the ownership of AI generated works, whether that's going to be a possibility. Clients are very interested in liability on both sides, whether they might be able to assert a claim if they think their works are being used to train an AI or might be showing up in search results. Clients who are thinking about, well, if we're doing something with AI in the course of our business, or we're looking to get into that area, could that expose us to liability? So they're very interested in that. And just sort of generally trying to figure out where it fits into their business model, if it does at all.
And Ekta, what about you?
Yeah, I think as Claudia mentioned, sort of in terms of IP, I think we can categorize the concerns into a couple of buckets. So we're getting the input related questions, how can I monetize my digital assets in the AI training process? And what's really catching steam is negotiating licensing deals for those digital assets. And then we're getting the output related questions, is AI generated content protected by IP? If so, who owns that? If something goes wrong, who's liable? And I guess specifically clients are really interested in understanding what they need to be thinking about if they're thinking about rolling out AI into the EU or the UK, or partnering with AI vendors that operate in those jurisdictions, particularly given the legislation we're seeing in that region.
Great. And Louise?
Well, I'm basically a transactional entertainment lawyer here in Los Angeles. So I represent producers, production companies, distributors, and talent, writers, directors, actors, artists, animators, the whole range, video game developers. And so I'm getting very practical questions. From the producer and distributor side, the primary questions are, what can I do with AI? What's allowed? Will I get sued for it? And how do I navigate the new AI terms in the recently negotiated WGA and SAG-AFTRA collective bargaining agreements? From the talent side, the question I get most often is, will I be out of a job?
Great. Well, I'm sure we're going to dig into more detail into all of those topics, but starting with Claudia, you had mentioned that your clients have been asking questions about liability risks in using AI and the uncertainty given the judicial decisions to date. So even if there isn't clear guidance provided, is there anything instructive in terms of best practices?
A lot of the issues that we're seeing in the litigations that are coming up are related to copyright, right? People are thinking about copyright infringement as the obvious tool. Sometimes you're seeing digital copyright management information claims. Sometimes you're seeing trademark infringement claims. So there are different species, but it really circles back to copyright infringement. So when we're thinking about those claims, you're really circling then to fair use, which is one of the defenses that's available to a defendant under Section 107 of the US Copyright Act. And you can walk through a copyright fair use analysis. There is an enormous body of law on that. We have new cases coming down all the time. The most recent one that people will probably think of is the Warhol case. Goldsmith v. Warhol started out in New York, went up to the Second Circuit. There was a finding of no infringement based on fair use at the district court level that was overturned at the Second Circuit and went up to the Supreme Court and was affirmed. There's actually a fairly interesting detailed, hotly debated, clearly decision where you have a very strong dissent as well. Lots of pictures for those who like those kinds of decisions, but we have a lot of case law on copyright fair use. And so you can walk through the analysis. What makes it challenging is that we don't have decisions that are squarely deciding that are final non-appealable decisions in the copyright fair use space in connection with AI specifically. So we have a little bit of a vacuum, but we have an enormous number of cases that have been brought in the last year to 18 months. Really still at the very early stages of those cases. We have a lot of complaints that have been filed. We have a lot of motions to dismiss that are pending. We don't have final decisions. I actually have one client that checks in with me fairly regularly and says, has anything changed with any of this? And I say, no, it hasn't changed in the last 2 months. But we're all sort of looking at those cases right now to see what happens with them. And you're seeing a lot of briefing and a lot of argument. So at some point we'll move past the commentary level of analysis and we'll get actual court decisions. That'll be very helpful. But in the meantime, we have a lot of complaints and a lot of briefing that's going on around these issues with the arguments pro and con.
And so that would be the US cases. ECTA, are there similar cases in the UK?
Much less so, Lindsay. So we're only seeing a couple of these cases crop up in the UK at the moment. But one of those, some of you might know, is that Getty Images has launched a parallel claim against Stability AI in the UK. And essentially, we're even further behind in the UK on getting clarity on these issues than as compared to the US. So Stability hasn't filed a defense to Getty's claim in the UK, but it did apply for a reverse summary judgment to have 2 aspects of Getty's claim sort of thrown out. And the High Court in December of last year ruled ruled against Stability AI, and we will now see the case proceed to full trial, subject to any settlement agreements. But what's interesting, I think, from a UK perspective, is that even though we are in this wait and see space, the reverse summary judgment application is still raising uncertainty for players in the landscape. So there are nuanced arguments about literal interpretation of the statute of Copyright Design and Patents Act 1988 in the UK, and whether or not it covers intangible items like software, which would then be restricted from being imported into the UK for use, sale, or for business use. And we're also, more broadly, I think it's interesting to see that the court hasn't considered that a parallel claim in a different jurisdiction is a barrier to winning that sort of territory point. So it has recognised the possibility of AI tools being able to be trained and developed across multiple jurisdictions. So yeah, it'll be interesting to see how these issues play out in a full trial.
But it sounds like there's still some degree of uncertainty and no real guardrails from the cases, at least.
Exactly, yeah.
Right. And taking AI and copyright from a different side of the issue, as opposed to infringement, do we have, I guess, guidance in the US first in terms of determining whether AI works are even protectable in the first place?
We do. You know, it's interesting. It's been an area that's really gotten a lot of attention in the last, say, year and a half. We have guidance from the Copyright Office, which came out last year in March and put out some guidance really landing on the side of copyright protection in the US is going to require a human author. It looks back at a case called Burrough-Giles from 1884, which talked about the copyrightability of photographs. And it's seen as a seminal case in the copyright photography area. That talked about authors as humans. And so the Copyright Office in its guidance looked back at that and said, look, you've got to have some kind of human agency. There has to be a human being who is making creative decisions, making creative choices. That's what generates the copyrightability of the work. And that's what we're looking for. So if you have something that's purely driven by AI, that's not going to be copyrightable. We also have a couple of instances where people are pushing the boundaries on that. And we have a couple of decisions, there are 3 or 4 of them now. 2 are particularly well known. There's an individual named Stephen Thaler who has worked in the AI area. He's an inventor, he lives in Missouri, and he's tried very hard to get protection for AI generated works. He's tried to do it through patent. It's been rejected in multiple countries, but he's tried to get patent protection. And he's also very aggressively gone after copyright protection. So he generated a work in the US and applied for copyright protection. That was rejected. He appealed. The district court found for the Copyright Office and found that the work was not protectable. It looks back at, again, the Burroughs-Giles case and says, look, there has to be a human author. You can't just have something created by machine, and walks through a really interesting analysis of that. That case is now up on appeal. He filed an appeal in January. And in the briefing, it's quite interesting because he points to cases like Google v. Oracle and says those recognize the possibility that you could have something that's created by a machine that doesn't involve a human being. The Copyright Office has come back in its opposition to that and pointed to very specific provisions of the Copyright Act itself that clearly require a human being. And one of them is another provision that's actually separately gotten a lot of attention lately, which is the termination provision. And that gives the author of a work the right to recover that work and recover the rights if they've assigned it to somebody after a period of 35 years. And there are various mechanics that are at play in that section. But one of the things that that section of the Copyright Act does is talk about what happens to the termination right after the death of the author. And who are the heirs who can then exercise that termination right, including a spouse, including children, potentially grandchildren, potentially trustees or executors. Clearly, that provision envisions a human author because you're talking about the potential demise of that human and then the living humans who are that person's heirs. And so the Copyright Office has pointed to those things as evidence that there has to be a human being. That, as I said, is up on appeal. We'll see what happens with it. Another one is an instance of a work called Zariah of the Dawn, which was a graphic novel. There was a human author who used AI to generate the images that are in the graphic novel, but then wrote the text and selected and arranged the images, applied for copyright. That was rejected. The Copyright Office has said that the selection and arrangement by the human author would be protectable, and that the text written by the human author would be protectable, but the AI generated images are not. So it's issuing a certificate only for the human aspects of it. But I think we're going to continue to see these things be litigated. We're going to continue to see the boundaries be pushed on this. And it's an interesting question, right? One of the things that Thaler has said is, look, I'm the author because I created the AI. The Copyright Office looks at that and says, no, this is different from things like photography, which is an example that people who are proponents of copyright protection for AI generated works often point to. And is, look, with a photograph, you have a human who is picking the moment to make the photograph. They are picking the location, the lighting, the setting, et cetera. And with AI, you have this unpredictability of the results. And so even if the human has created the AI itself, what that AI then does is unpredictable, and the human is not controlling it and not exercising those creative choices that we want to see for a protectable work of authorship. So it'll be very interesting to see how that plays out and what happens with the Thaler appeal. But one of the other things that we're looking to as well, again, the Copyright Office in the US is driving much of this. So they put out a request for public comment last summer, received over 10,000 submissions from all the usual players who you would expect: copyright work generators, copyright work users, AI platform companies. Shira Perlmutter, who's the Register of Copyrights, has said that the office is looking through every single one of those 10,000. It'll be interesting to see what comes out of that, but it's looking for input and guidance from people who are actively involved with AI and with copyrightable works and trying to see how it can synthesize those and think about rulemaking going forward. So I predict at some point we will see something coming out of the Copyright Office in response to that as well.
Great. And Ekta, in the EU, have you seen the same sort of approach in terms of protectability?
So I think there's some divergence there, Lindsay, that's interesting to draw out. And there's certainly also divergence as between the UK and the EU between themselves. So unlike the US, there isn't a general sort of fair use defense. in the UK or the EU, but rather a set of sort of explicit exceptions to right holders' rights. So kind of taking at an input stage, in the EU in 2019, as part of the Copyright Directive, an exception was introduced to copyright and database rights that allows for text and data mining, which is essentially what we're talking about here. I guess the statistical analysis, or using statistical analysis to mine existing data sets for patterns, trends, information, which is how AI works. And the exception essentially allowed for AI developers to access lawfully accessible works and use them for commercial purposes. So all of this publicly available information is essentially up for grabs. There is an opt-out right for right holders in the EU. So if you're a rights holder, you can opt out so that people can't mine your work. And you can do that in practical terms in a machine readable format on your website. So nowadays, major sort of AI system providers have provided specific instructions on how to do that with respect to their own respective training processes. So if you go on OpenAI's terms of service, you'll see a section entitled Opt Out, and it reads, if you don't want us to use your content to train our models, you can opt out by doing X, Y, and Z. But the important thing, I think, to remember in the EU is that even if there is an exception, it's unlikely to capture all AI training activity. And then, together with the general uncertainty as regards sort of pending litigation, we're really seeing licensing emerge as a solution to that. And so even in the EU, we've seen deals between OpenAI and companies like Le Monde in France to license their archival data. And then in the UK, there is also an exception to text and data mining, but it is restricted to non-commercial research purposes, so largely useless for AI developers who are training these models for commercial purposes. And in the UK, it's been quite interesting. I think there's been quite a bit of back and forth on this. So back in 2022, the UK government announced that it wanted to introduce an exception for text and data mining, but without any opt-out rights for rights holders. So rights holders wouldn't be able to opt out, they wouldn't be able to contract out or charge for their digital assets via licenses. Obviously, we can expect, as expected, there was backlash from creative industries with respect to this proposal, and that was subsequently axed. And then following that, last summer the government announced that stakeholders from both sort of AI companies and also creative industries would come together to put in place a code of practice that would, in essence, identify some solutions to this problem. But in February of this year, the government announced that had also fallen through. And that's not hugely surprising, right? Because I think there is an increasing tension here between rights holders and AI companies, and kind of putting everyone in the same room and saying, just figure it out between yourselves is unlikely to work without any legislative backing. So here there's a little bit of clarity that we're wanting to see from the UK government, and I do think the UK feels a bit up against the clock on this as other jurisdictions move to provide a little bit more clarity. And then on the output side, in the UK, the Copyright Act does grant protection to computer-generated works. So any works that are generated by computer in circumstances where there's no human author is protected for 50 years from creation by the AI author. But the EU's position, in contrast, is much more similar to the US in that the basic approach talks about protecting the author's own intellectual creation. So it seems pretty problematic in the AI context. That's the sort of current IP position. I just want to spend a couple of minutes talking about existing frameworks, because what we're really seeing in the EU is regulators applying existing regulatory frameworks to these novel concepts. So, I hate to say it, but the General Data Protection Regulation in the EU is really sort of living up to its name of being the so-called law of everything. Last year, we saw the Italian Data Protection Authority, the Garante, temporarily ban ChatGPT in Italy. And that was amidst sort of concerns that OpenAI didn't have a lawful basis to be using publicly available data in this manner. And also concerns that the output of ChatGPT wasn't meeting the accuracy principles and thresholds that are stipulated in the GDPR. Now that ban was subsequently lifted, but the investigation is still ongoing, and there are some really tricky issues there around the use of particularly sensitive personal information by AI developers. Another sort of less exotic example is the UK's Information Commissioner also took enforcement action against a social media company called Snap. And that was for essentially rolling out an AI chatbot without having properly documented its data privacy impact assessment. So I guess it's really going to show that, companies need to be looking at adjacent frameworks as well and taking a holistic approach to compliance in this area.
Thanks, Ekta. And you mentioned the licensing point, that's one approach that people have been taking. And I wanted to circle back to Claudia just to speak a little bit about the actual infringement cases, which I know we discussed haven't provided much guidance yet, but definitely have interesting sets of facts, and we'll see, Claudia, if you could tell us about them.
Yeah, and it's interesting because you see this licensing issue coming up in the United States, and we have seen instances of licensing. So, for example, the Associated Press has entered into a license for its database, and obviously it has a vast resource in terms of its archive of both text materials and photographic materials. It has a tremendous picture archive, and there are other archives as well. So that's a significant licensing arrangement that's been entered into. And we see these licensing issues coming up in the lawsuits that have been filed. So, for example, the New York Times, which sued Microsoft and OpenAI last December, has argued that its licensing business is a crucial part of its business model. It says it has over 10 million subscribers and it licenses its content to those subscribers. It has other sources of revenue like affiliate deals, but really the ability to license the content is crucial in order to support the journalism it is engaged in and to facilitate the creation of additional works by the New York Times and all of its different journalists, photographers, et cetera. And you see in the complaint in that case, the New York Times saying, look, we realized that our material was being used or had good reason to think it was being used. We put them on notice. We tried to work out an arrangement. It talks in its complaint about months of settlement discussions and says when those discussions were unsuccessful, that's when we filed the lawsuit. And it points to a couple of uses that really track what we're seeing in other places. And as Ekta talked about, the use to train the AI and then the use in the output. So that the New York Times is saying, look, our repository of material, we have an archive that we make available to subscribers, that's being used to train the AIs, and we're seeing material show up in material that's put out by the AI. You can see that in some of the output that we get when we prompt it. And there's an Exhibit J to the complaint that's over 100 pages of examples the New York Times says was generated by prompting the AI with questions about New York Times articles, and then led to the generation of verbatim paragraphs from those articles. It also says that, look, the output is infringing as well, and both of these things are problematic, that we would have the ability to license our content for use as training material, and we are now being deprived of licensing revenue because people who would subscribe to the New York Times are instead going to get it through searches that are generating our verbatim material. You see this in some of the other lawsuits as well. There's a case involving UMG and other music publishers against Anthropic, which says that, look, your Claude function, if you prompt it, will generate song lyrics. The complaint gives an example of a question about Buddy Holly and getting verbatim lyrics to the song about the day the music died. And you have an exhibit in the complaint that compares the chat that the AI generated results and the actual lyrics of the song, and you can see that they're virtually identical. And it gives multiple examples of that and says, look, obviously the music business runs on licensing. You are charging people for access to and use of the music, including lyrics and then sound recordings. This is a real problem if you're not going to get that material from the original owners and license it properly. And then we also have the Getty lawsuit, which is a corollary to the one in the UK. We obviously have a decision in the UK. We don't yet in the US. But when you look at the Getty complaint, they're talking about the licensing business and how that's being threatened, that they have an archive of millions and millions of works. And when you look at the stability AI generated results, you will see works that, according to the complaint, when you look at the examples it gives, have taken pieces of images, and in some instances, even the Getty watermark. So you will see an image showing up in the stability AI generated search result that reproduces the Getty watermark. And so all of these are businesses that are very driven by the ability to generate revenue through licensing the content. And they're seeing that under threat from the AI platforms. And so this is sort of replicating what we're seeing in other sectors. For example, the music sector more purely, where you see streaming platforms are using those works. And obviously in that context, we have a compulsory licensing system where the Copyright Royalty Board sets rates and it's understood that these works will be used. We don't have it for these other types of content where now there is a tech-driven platform that's able to use them. And it'll be interesting to watch these cases going forward. As I said, there's a lot of motion practice, motions to dismiss are pending. A lot of the AI companies want to move some of these cases to the Northern District of California, where there's been some success with motions to dismiss, although there has been leave given to replead those complaints. But it'll be really interesting over the next year or two as those play out. And we also see these licensing driven models that are under economic pressure and how they are adapting or not, maybe along the lines of the Associated Press, which, as I said, is licensing its content.
And that's also a good plug for the reference materials that we circulated for this panel, because if you haven't taken a look at some of the complaints, they're very compelling and entertaining just to see what the AI is generating and why the plaintiffs might have an issue with it in these instances. So all this discussion sets the stage to see how people have, or how entities have been acting in the absence of clear guidance. And as we've been grappling with all these issues, and the example is union contracts. Louise, can you explain how these issues have been dealt with in that context?
Thank you, Lindsay. Well, as you said, in this vacuum, the Hollywood unions were facing some difficult questions. In particular, the Writers Guild of America, the WGA, and the Screen Actors Guild, SAG-AFTRA, had a number of genuine concerns about how generative AI would affect their members. And in fact, their collective bargaining agreements with the Motion Picture and Television, the Association, the Alliance of Motion Picture and Television Producers, their collective bargaining agreements were coming up for renegotiation. They were expiring. Just a side note for those of you who are not familiar with the entertainment industry, I've included in your written materials a very simplistic glossary of some of the acronyms and shortcut titles that I'm using in this talk, and this may help you. For example, the AMPTP, the collective bargaining entity for the producers, is also sometimes referred to as the studios, because the studios were originally the lead members of that organization. Now they are joined by a number of the streaming platforms like Apple, Netflix, and Amazon MGM, all of whom are investing in various forms of generative AI. So their interests are slightly different than the pure content producers. So what were the concerns that the guilds had, and what were the guardrails that they thought they could put in place? In preparing for their strike positions, the guilds basically took a deep dive into the terms and conditions and the structures that were created by the pre-existing collective bargaining agreements to protect their members. So this is going to get a little bit detailed, but I'll do the best I can to explain it. Keep in mind that only union productions are covered by these guardrails. Non-union productions, those that were done by non-signatories, companies who are not signatories to these collective bargaining agreements, and companies and talent who are not members of these agreements are not covered. And that includes, importantly, a substantial number of productions outside the US. So let's start with the Writers Guild and see how far we get. At the time of the negotiations, it was pretty clear that generative AI was not going to replace writers entirely. There are some things that generative AI just doesn't do well yet and may not for a long time. For example, it can't come up with jokes, at least not intentionally. The Writers Guild focused on ways in which generative AI could diminish compensation and screen credits as they were provided under the pre-existing contract. I'm going to try and talk about 5 of these concerns. Please keep in mind, this is my own brief summary. It doesn't reflect the union positions. It doesn't reflect the studio's positions. And if you're looking to address specific applications of these agreements, nothing substitutes for going back to the language itself. My idea in presenting this is basically to give you some ideas about how much can really be done through contract, whether union contract or individual contract, to put guardrails on generative AI. First, the Guild and their members were concerned about the prospect of a studio or production company using generative AI to produce a completed script and then wanting to hire a writer to finish it at the reduced rate applicable to rewrites and polishes. Again, a bit of background here. When it comes to writers' compensation at least for motion picture screenplays, minimum payments in the collective bargaining agreements and in individual agreements themselves are generally structured around the particular type of material to be produced or being commissioned. So there's a certain minimum payment for a first draft of a screenplay. If the writer's hired to do rewrites, the payment for that is less. If the writer's hired to do a polish, the payment for that is even less. So if a producer wants to use an AI generated screenplay and have it revised, they're basically cutting the writer out of that higher payment for writing a first draft screenplay, or trying to cut a writer out of a higher payment. And that may also affect the writer's credits, because writer's credits, screen credits, are determined by how much of the final work was contributed by that writer. There's a complicated process that involves notice and objections and arbitration to determine final screen credits. Screen credits are important to writers and other talent, for that matter, because they determine the writer's place or the talent's place in the hierarchy of the entertainment industry. and can specifically affect how much they get paid on their next project. So, for example, if you get screen credit for writing a hit film, your price goes up. It seldom goes down, but sometimes goes down if you get credit on a total dog. So how did the WGA and the studios resolve this issue of being asked to rewrite a GAI generated script? Basically, they agreed that the producers would be able to do this, to hire a writer to revise or polish a generative AI script, but it deems the writer's creations as an entire original screenplay, not a rewritten work compensated at a lower level. The second area of concern was the possibility that the producer might try to use generative AI to produce what's called source material, like a novel or a stage play, and then hire a writer to adapt that material at a lower fee. And also, potentially, this would deprive the writer of certain reserved rights in the finished work, known as separated rights. These include notably, in the generative AI context, the right to publish the screenplay. And these separated rights are available only for completely original works. Even with completely original works, a writer might not be entitled to them, but for adapted screenplays, they are not at all available. So how is this concern addressed? Well, under the new collective bargaining agreement, the 2023 agreement, the producer is permitted to use generative AI to generate source material, but that will not be included within what the agreement defines as quote unquote literary material. As a result, the writer's adaptation will be considered an original screenplay, not an adapted screenplay, for purposes of determining the applicable rates of pay, the credits, and whether or not the writer is entitled to separated rights. It is important in this context to note that, like this issue in the US, where to own a copyright in an AI generated work, you have to be a human being. The collective bargaining agreement, the studios agreed to something very specific. And this is the only time I'm going to try and quote fairly closely specific language. They say that because neither AI nor generative AI is a person, neither AI nor generative AI can be considered a writer or professional writer, as those terms are defined in the agreement, and as those terms are used to give certain rights to writers and professional writers. In general, the agreement says material produced by AI or generative AI are not included within the definition of literary material, as I mentioned before. The third concern was that producers would try to use generative AI to edit or rewrite a script done by an actual writer, which would in effect cut the writer out of prospective additional payments for rewrites and polishes, and would also reduce the prospect of receiving credit because of the more limited extent of the writer's contribution. How is this concern addressed? The collective bargaining agreement now specifically prohibits the producer or producers in general from using general AI to edit or rewrite an actual author's literary material. That's just absolute. There's no general prohibition against the use of generative AI, but it may not be used for editing or rewriting what a writer has done. The fourth concern was the possibility that the producers might try to require the use of generative AI in creating works if the writer wanted to be employed at all on the project. Basically, this was resolved because the producers agreed that they would be prohibited from conditioning writer employment on the writer's use of generative AI. More generally, the producer needs to disclose to the writer whether generative AI has been used in any of the material or source material presented to the writer. And they can use generative AI material only with the writer's consent. Conversely, writers cannot use generative AI in preparing their works unless they have the consent of the studios and follow the studio's policies and guidelines. There's a fifth and more complicated concern that was raised, namely whether or not a writer's literary material could legally be used to train generative AI, their large language models, or to produce text in response to prompts. This was a difficult issue for a couple of reasons. First of all, who owns the rights, if any, as Claudia has described? Who owns the rights to use a script for training or output, at least in the US? For works written in the scope of a writer's employment, the copyright is owned by the employer as a work made for hire. Similarly, a script by a writer done as working as an independent contractor on a commission from a producer belongs to the producer, again, as a work made for hire. For an original screenplay created by a writer on his or her own initiative, the initial copyright vests in the writer as the author. However, in most screenplay acquisition agreements, the writer must assign all rights to the producer. The one exception, of course, is that there are certain reserved rights. And remembering what I mentioned about separated rights, one of the most important reserved rights is the right to publish the screenplay itself as text. So under both the separated rights in the collective bargaining agreement and individual contracts, these rights are retained by the writer. There's reason to think that when generative AI trains its large language model, these screenplay publication rights are implicated. And I think that's particularly true in light of the fact that Google has admitted that it is transcribing audiovisual content into text from works on YouTube and then using that to train Google's generative AI. I mean, obviously, those are not largely covered by collective bargaining agreements, but this may be perhaps a trend that we're seeing. So basically, the Writers Guild and the studios were not able to resolve this issue by mutual agreement. So in the collective bargaining agreement, they pretty much punt. The studios and producers may well own whatever rights are needed to authorize GAI training and output, but in the collective bargaining agreement, the writers will not be restricted from pursuing such claims, if any. And as you heard from Claudia, in the US at least, it's unclear whether there are any such claims, and if there are, whether those are defendable based on fair use. Now, let's take a quick look, if we can, at what SAG and AFTRA did.
Okay.
Do you want to stop there and take a break? And if there's time, we'll get to it later.
Yeah, no, definitely. It would be great if you could cover it briefly, and then we can, have everybody chime in.
Okay. Generative AI is much more of an existential issue for actors than it was for writers, at least at present. Once a digital replica is made of an actor, at least someone who's not very famous or well known, that actor may never work again. And in theory, a producer could just use that for future performances. Like the WGA, SAG-AFTRA took a look at its pre-existing contract and based its approach to this issue on provisions that the contract contained for the reuse of clips in new motion pictures. If you want to take a clip from a film or and put it in a new motion picture, either as in the background or as part of your storytelling, you basically have to get the consent of any performers who appear recognizably in that clip. Then, of course, to get that consent, you likely will have to negotiate some sort of compensation. So the SAG-AFTRA agreement focuses on two types of generative AI characters or performers. The first is a character that's a composite of many different individuals, but not recognizable as any one individual, and that's referred to as a synthetic performer. The studios, the producers, are free to use such a character, but they have to first notify SAG-AFTRA and negotiate with SAG-AFTRA compensation, basically, that they would have had to pay if they'd used a real life actor. I think there's going to be a lot of pushback on this from the producers, whether or not they're really going to give the notice, whether or not they're really going to negotiate in good faith, or whether they're going to maintain that this is something they can use freely. I think this will especially happen in the commercials area when the commercials contract comes up for renewal. For recognizable creations, generations, there are several categories of what are described as digital replicas. But the bottom line for those in all these categories is that the producer has to get the consent of the actor to use a digital replica of them. The consent has to be knowing and conscious. The producer has to give a specific description of the intended use. So in other words, no blanket prior authorizations hidden in the boilerplate of a contract allow that use forever. The producer has to provide the actor, as I said, with a reasonably specific description of the intended use. In many cases, it seems likely that the producers will argue that their compensation, that the compensation they owe the actors will be limited to the minimum set forth in the contract. Obviously, actors will try to negotiate more. Interestingly, these rules do not apply to the most highly paid performers, who are referred to as Schedule F performers who meet certain payment thresholds. They're assumed to be able to negotiate their own deals and know about the issues involved. So that's, in the very briefest sense, the SAG-AFTRA guardrails. They are not going to be specifically applicable, I think, to other situations outside the entertainment industry, although they will inform and be used in other entertainment industry collective bargaining agreements.
Thank you so much, Louise. And it'll be interesting to see how it practically plays out and whether this leads to litigation and interpretations of the agreements. We want to switch gears a little bit to go back to the UK-EU approaches, and then eventually talk about negotiating license agreements there. But to start, the EU is developing AI-specific legislation. So I want to see if Ekta could talk a little bit about how the EU's new AI Act fits into all of this, into everything we've been talking about with existing IP and data laws generally.
Yeah, absolutely. So the EU's AI Act really is something. It's the world's first sort of binding comprehensive law specifically related to AI. And it is in its final stages of implementation. So we're expecting it to enter into force by the end of this year. The first thing that I think is worth mentioning about the Act is that it's pretty broad in territorial scope. So I think for US listeners today that might feel like they're pretty comfortable that the Act won't apply to them, I would urge you to think twice. So it applies to any AI systems that are placed on the EU market, but also to any AI systems that are used by citizens in the EU, as well as AI systems whose output is used in the EU. So pretty broad. It also applies to both providers of AI tools. So an AI developer that's, for example, developing a CV screening tool, as well as deployers of those systems. So any companies that buy and utilize that CV screening tool. And the Act, interestingly, didn't, envisage touching on sort of aspects of IP or copyright law, but there are some interesting things that stem from it. So in general, it's a tiered regulation that categorizes obligations based on how risky an AI tool is. So essentially, the higher the risk, the stricter the rules get. And up top, you've got a couple of use cases that are absolutely prohibited. So it talks about things like real-time biometric identification in public spaces, or any AI that manipulates human behavior or exploits people's vulnerabilities is prohibited. Then you've got a sort of high risk category, which attracts most obligations under the Act. The Act describes this as including things like AI systems that are utilised for employee recruitment, anything that's used in sort of critical infrastructure, border control, access to essential services. So if you've got an AI tool that helps to provide individuals with a credit score, that all falls within that high risk category. And this sort of AI is going to be subject to pretty burdensome obligations. So the Act talks about having that system go through rigorous testing, maintaining use logs, maintaining proper documentation that speaks to the quality of the data that's being ingested, and an accountability framework that involves an appropriate level of human oversight. And individuals will also have a right to submit sort of complaints about this type of AI. I think most interesting for the group here today is a third category, which is specifically for general purpose AI systems. So here, as a baseline, you need to comply with certain transparency requirements. And from an IP perspective, there are two key obligations that are worth mentioning. So the Act requires providers of general purpose AI systems to firstly put in place a policy to comply with EU copyright law, and in particular to identify and respect opt-outs from the text and data mining exception that we were speaking about earlier. So the implications of this are really interesting because essentially, there's an argument that even if you go to a really permissive country to train your AI, if the AI system then falls within scope of the EU AI Act, you still need this policy and you need to respect EU opt-out rights. So whether that essentially means that the EU text and data mining exception and the respective opt-outs need to be respected outside of the EU is something that will be interesting to see when we have further guidance on this. And then the second obligation on providers of general purpose AI systems is an obligation to draw up and make publicly available a sufficiently detailed summary about the content that is used for training that general purpose AI system. So here you can really see an effort by the EU Parliament and the Council to protect EU content creators and equip rights holders. And I think what's interesting about this obligation is not clear at this point in time, how detailed this summary needs to be. But it might give rights holders enough transparency to go out and opt out of the text and data mining exception if they haven't done so already. And that's going to potentially further drive licensing activity. So I think just quick takeaways on that are that we do have some really helpful guidance in the EU, but what's going to be interesting is how this all plays out in practice. The one thing I will say is people are predicting the so-called Brussels effect for the EU AI Act. And so even if you're comfortable that the EU AI Act doesn't apply to you, that you could have a competitive edge in getting ahead of those obligations now, as we see other jurisdictions mirror certain of these obligations. And given this landscape, I think it's also going to be interesting to see certain regulatory perimeter issues arise. So I think there is going to be a real effort to try and categorize AI systems as falling in those lower risk categories that attract lesser obligations, and perhaps some level of back and forth between legal and marketing teams on how they frame their tools.
Great. Well, the general theme here seems to be we'll see. So I thought with that, maybe we could pose some general questions to the panel and then turn to some of the audience questions. But I was curious to know what industries do you think may be most impacted by AI, and how so? Anything unexpected, or sort of what you think? Will we still have our jobs? That kind of thing.
It's interesting, right? You mentioned at the top that I had written an article about somebody being sanctioned for using AI tools, and generative AI in particular, to do legal research, right? And you can see that it could be a disruptive tool for some types of legal work, right? I know somebody who is telling me about how they use ChatGPT to draft a contract. I think there are some things where it might be quite useful. One of the things it doesn't do well is legal research. We all know that once you get the cases, you then have to read them and analyze them and figure out how they relate or don't relate to your case. And it really involves elements of judgment and analogizing things and distinguishing things. So I think that there may well be areas of the legal field, if you think about things that have been commoditized over time, there will be other things that are commoditized over time. But I think that, it's almost like there's an arms race, but if you're on the front of that edge, you're always going to have things where you do need human judgment and human analysis. And there are things that you only know about because you've been doing this for some period of time. And then you're going to be able to train people to do the things that you know how to do in a way that an AI can't necessarily do them. So I think, yes, in our area, there will be things, but then there will be some things where it just doesn't work. And I think you're going to see that all over. We see this, so many clients in so many different areas are really interested in AI. We have clients that are in the obvious sort of spaces like news media and things like that. But then clients are looking at AI. I was just reading an article about, is AI going to come for interior decoration, right? Is that an area where you're going to see it be a disruptive tool? And, interior designers are saying, look, I use it because I can get renderings done more quickly. They may not be the fine-tuned ones, but for quick and dirty purposes to explain to a client what I'm conceiving of, yes, it's useful. But then to actually make the decisions about what goes where and what kind of space you actually want to live in, they don't see those functions, which again are the higher level functions, being taken over by AI, or at least not anytime soon. So I think it's something where I don't know that you could find anybody who's not worried about it. But is it definitely going to threaten every industry? I'm not convinced of that.
My general sense is that generative AI will do to white collar jobs essentially what, at least lower level white collar jobs, it will do essentially what robotics did years ago to blue collar jobs, which is wipe out a lot of the lower level jobs. Um, Certainly it's already taking effect in customer service situations, um, replacing salesmen trying to qualify potential sales prospects. And in the entertainment industry in particular, I see a lot of risk for people working in the visual arts and people working in areas that are not unionized, which won't have the benefit of a collective bargaining agreement. For example, I have one client whose passion is comic books, and that's what he loves to do, is create and draw comic books. But he can't make a living doing that. So up until now, he's been hiring himself out to create storyboards for film and TV shows, which are an essential part of what the director does in laying out their shots. And I think storyboards are going to be, at least in part, taken over by generative AI. The images won't be as good, they may not be as creative, but they're going to be cheaper and faster than using a real person. So the entertainment industry is going to be grappling with these issues for a long time.
Great. And another question in the context of everything we've been talking about with the global approaches, how do you account for the different approaches taken in the US and abroad? And what challenges do you think will result with respect to advising clients as to AI issues?
I mean, it's an interesting question, right? And I think it tells us that we're going to need even more interconnectedness than we have now. And I've had situations where I've advised clients on cross-border deals where they're considering acquiring an asset portfolio, for example, that has copyright issues. And we're looking at things like, what is the copyright term in the US versus pick one of 35 other countries, right? And so we're already thinking about that. But I think that global interconnectedness is going to have even more emphasis where, as Ekta said, you've got activity in the EU, in the UK, where maybe they're a little bit ahead of us in terms of actually having things on the books that will tell you how this stuff is supposed to work. And we're waiting for judicial decisions that may be a year or two or more out. We're going to need to be talking to each other and understand what the different guardrails are in different jurisdictions. And I see clients already asking about that and asking us to partner with folks in the UK or the EU or other places, because they understand that it's going to be fragmented even more than it already is. I think it'll make these really interesting issues even more interesting, but it will be an additional challenge. And I think it'll be something that you really have to keep an eye on. It'll be easy to miss things, right? And so I think it'll really put a lot of emphasis on being up to speed or working together in a more collaborative way where, you can't know everything, but you can know people who know a lot of different things, and we'll need to work together on that.
Yeah, I mean, exactly, echoing Claudia's sentiments on that. So there is that obvious issue of trying to deal with a myriad of varying global laws in this space. But I don't think that's a new problem. I think companies have been dealing with that in other areas for years now. And I think the key, things that I would suggest focusing on is understanding what the key rules are in the jurisdictions that you're operating in and how they apply to your business. and then deciding whether you want to address compliance on a global level, and accepting that in some cases that will mean over complying in certain jurisdictions, or you want to address it on a jurisdiction by jurisdiction basis, which may operationally be more difficult. And yeah, certainly kind of pairing up with global advisors that can help with that comparative analysis and streamline compliance efforts can be really helpful.
Well, I'm sure we'll be seeing a lot more panels, cross-border ones with people from different perspectives sharing with each other the laws. So I wanted to turn now to some of the audience questions. One in particular from Sarah Cobble. She asked, what questions are you most looking forward to the court's answer in terms of the ongoing evolution of copyright, generative AI, and data privacy? So yeah, I mean, we're all waiting court decisions. So what are you most excited to see?
I mean, for me, the number one question is how is this going to play out in the fair use context? And we've got so many cases that are teeing that issue up. But even before the lawsuit started to be filed, you were seeing, commentators on both sides, people who were in favor of more aggressive enforcement of copyrights versus people who thought that, we really needed to have more freedom for innovation and that we needed to have more leeway to use existing works to create new things. And I always feel that in the copyright area in particular, so many issues that come up are old issues in new clothing, right? We can go back to the US Constitution, which talks about copyright as a tool that's designed to encourage the creation of new works, right? That's the purpose. So we give people a limited time monopoly, and the idea is that we're incentivizing creators to make new things because they can earn a return from that. They can support themselves by generating copyrightable works and then selling them or licensing them. And what we're seeing now is just another iteration of that. So I think that the tension already exists between wanting to ensure that return for the original creator so that you don't kill the golden goose and cut off the ability to make new works, but you also want to encourage innovation, and you're trying to balance that. We see that balance being drawn in the music space between the return to the creators of musical works and the return to the creators of the streaming platforms, right? And there's been a balance that's been struck, for example, in the rate decisions that come out of the Copyright Royalty Board. So to me, the fair use is going to be a tricky question. It'll be really interesting to see how the courts decide it. As I said, we do have a large body of fair use law, but you keep seeing it evolving as we have new technologies. It's been happening for decades, but that's the thing that I'm most interested in, because I think it really has the potential to go into so many different areas and touch on so many different sectors of our economy that it'll be an important decision when we actually get one.
In that regard, I mean, I think it's going to be very interesting to see where the courts draw the line between a derivative work and a so-called transformative use, and where the courts draw the line between the Google book search decision and the Warhol decision. Because at some higher level of generality, I mean, almost any adaptation of a copyrighted work could be considered a derivative work, but that's not how the court in the Google book search decided to handle the issue. So I think this line drawing is going to come up in the pending cases Claudia talked about, and in a number of other cases as well.
Right. And you see that pendulum, right? We had Google Books and then you have Warhol, and you can almost see that as the pendulum swinging back and forth. We see that at the circuit court level. So it'll be interesting to see where they draw that line in the next iteration.
I think from an EU and a UK perspective, I'm not necessarily from courts, but I'm really looking forward to some guidance, supporting guidance to the EU AI Act on that extraterritoriality question. So the bit that we're really wanting some clarity on is whether the intent of the European Parliament and Council was for EU text and data mining opt-outs to be adhered to globally, because we know that when they went into sort of drafting that, the intent was to create a sort of global playing field and not have the sort of race to the bottom for more permissive versus less permissive jurisdictions for training AI. So that's a really interesting one that we'll be keeping our eyes on. And then I think the question also asked about data privacy, and there's so much in this space that it will be really interesting to see some guidance on. I'm particularly interested to see whether the regulator might decide that legitimate interests isn't the legitimate interests of a company aren't an appropriate processing ground for using publicly available information to train AI models. Because essentially what that means is that companies, AI developers will be faced with going out and seeking consent from basically the whole world. So that seems pretty impossible. And also how individual data rights are going to be adhered to, right? Because if we are ingesting personal information into AI tools, individuals have rights in respect of that data. So I could ask for my data to be deleted or corrected, and there's some really nuanced issues about the potential impossibility of that, whether AI tools can unlearn the data that's been ingested into it, and whether there are practical realities around that. So all of that is stuff that I'm looking forward to getting some clarity on.
Great. And another question that I had wanted to ask Louise, but we had run out of time during that portion, was just whether putting your position on where the unions landed aside, are there any obstacles or challenges that you see given where they landed on the language?
Well, I mentioned one, that is, not all production and not all entertainment industry agreements are going to be covered by the collective bargaining agreement. So there's an issue as to whether or not talent is going to be able to negotiate similar guardrails in individual agreements, and outside the entertainment industry, whether or not people are going to be able to negotiate individual contracts to include these kinds of guardrails. Another challenge is enforceability, because under the collective bargaining agreements, the enforcement mechanism is a union grievance process followed by arbitration. And these do not necessarily result in court precedents. There's some effort within the industry made to follow a consistent line, but it's not as obvious as that. And there are challenges for industries like visual special effects that are not essentially unionized. Same thing for games. So it will be interesting to see. There are a number of contracts coming up or in the process of renegotiation now. The American Federation of Musicians has recently concluded a tentative agreement, including AI. The details are not available until ratified. The IATSE craft unions are in the process of rather long drawn out negotiations of individual specific craft issues, and will turn to AI as a general issue applicable to all of their craft unions, including animation writers, hair designers, costumers, editors, and cinematographers. And it's not clear that those will require the same sort of resolution, but I think disclosure and consent will be among the big touchstones.
Great, thank you. And back to the audience questions from Joe Mazzarella. He wanted to know whether our panelists can talk about copyright dilution, where an owner takes a copyrighted work as data and generates a derivative work that is machine derived, I would think there would be a risk of losing control over the IP to the extent it is transformed into a non-protected work. If you could speak about that.
Yeah, it's a really interesting question because you could imagine a situation where you start off with a copyrightable work and then there is a derivative that is created based on that. And you can go through generations and maybe at some point generative AI becomes involved in the creative process. And there is a derivative that is created by the AI. And under the current Copyright Office guidance in the US, that would not be copyrightable. And so you could have the situation where through that derivative work process, you do lose control of some aspects of the IP because now you have a work that could be used by somebody. It's not protectable by copyright. How do you protect it? If it's out there in the world, it's not a trade secret, for example. You may have contractual restrictions, but those won't work for the general public. So I think it is a real challenge. And we do see clients who are frankly concerned about this, who are wondering about how to use AI in the creative process without the risk of losing control over their IP and the works that they create and the ability, again, to license those and leverage them to generate revenue. So I think it's a real issue. And I think that is in part why people are so concerned about what is the test for copyrightability and can something that's generated by AI be protected? Because if it can't, that may in some sense be a natural limit on the willingness to use AI to create new works. Because you're by definition creating things for the public domain with no ability to control those works or generate revenue from them. So that is why we're seeing those questions. I think it is a real question. We don't know the answer yet. We're still waiting for court guidance or maybe statutory limitations that tell you, yes, you can protect these things. Right now in the US, it's a real thing because there is this guidance from the Copyright Office and we're seeing court decisions now, including in the Thaler case, saying that these works are not protectable. So if I were somebody who is generating copyrightable works, I would be concerned about it. And you can see that could be something that comes up in all kinds of different areas.
Yeah, and I think from a UK perspective, essentially the rule is that you infringe someone else's copyright if you substantially copy it on a qualitative basis. So you would need to identify a work which has been infringed, and then the output needs to be substantially similar. But obviously, we know that a lot of the time AI-generated work might not infringe a particular work because it's a derivative, or it will likely have amalgamated numerous sources to create the output. I think I'm putting Claudia on the spot, and she'll correct me if I'm wrong. In the US Getty Images case, they're raising the prospect that all generative AI outputs are of necessity infringing, and that's on the basis that you sort of bring a class action by everyone that's ever submitted something to Getty, and then by mosaicing that together. Is that right?
Yeah, and it's interesting because it gets to this question of how is the AI being trained? What are the outputs? And you're right, you can have a composite output. And if you follow the theory through, you could argue that that output is infringing, even if it's of many, many different works, right? But then you get to the issues that we look at in copyright litigation. Is it substantially similar? And I think that then poses, frankly, a real challenge for the courts in looking at a given work that has been generated by an AI. Is this substantially similar? And if so, to what, right? Because Getty, when you look at its examples that it put in its complaint, shows some images, and some of them look more similar and some of them look less similar. Some of them do replicate the Getty watermark, which you could say, okay, that's a significant similarity. But then is the underlying image similar? And some of them, yes, and some of them, maybe you could debate it more. So I think that's going to be an interesting piece of this, and why the fair use analysis is so interesting and potentially challenging, right? And then we have the influence of the technology. What is the technology doing? Are you making copies? When you go through the fair use factors in the US, those factors are 4 statutory factors that are set out in Section 107 of the Copyright Act: the purpose and character of the use, the amount and substantiality that is used, the nature of the underlying work, the effect on the marketplace, which is something that the Supreme Court in the Warhol decision said needs a lot of attention. And then this question of, you can't just be derivative. It has to do something that necessitated the use of the copyrighted work in the first place, because if it's merely derivative, then it's infringing. And so you've got all those tensions, but when you aggregate works and then you're generating output, and that output itself is aggregating perhaps little pieces of underlying copyrightable works, how do you deal with that? And is there a substantial similarity test that's going to be capable of accommodating that kind of claim, right? That is this going to be one of those instances where the system doesn't know what to do with it? You know, so far, copyright has been flexible enough to accommodate all kinds of different things, but I think this could be a challenge.
Switching gears a little bit back to the issue of protectability under copyright in the US. The fact that the Copyright Office has said that only the human contribution is protectable, I think you're going to end up with some very thin copyright protection in a lot of areas, because what's protected may be only the arrangement and editing elements of a particular work, or as we said with the comic book, the AI generated comic book, only the text but not the images. And so this is going to reduce the extent of copyright protection and also raise some additional issues, like Claudia raises, about substantial similarity. What are you comparing it to? Are you saying that they infringe the editing and arrangement of the works? Or are you talking about a more general kind of substantial similarity between the works themselves?
And you know, it's interesting. We see in music cases, you often have expert testimony that gets into a very granular analysis of music compositions, right? Where they're going note by note. You know, sometimes it's the themes, sometimes it's the chords, sometimes literally the notes, and it can be very granular. And then one of the questions I have is, how are you going to parse these works in an AI context? It's a little bit more straightforward sometimes, or at least might seem to be, with a text work. And you see in these complaints examples where one column of text is laid next to another column of text, and they highlight the words that are identical. And you're like, wow, there's a lot that's highlighted there. It'll be very interesting to see as these cases play out, what is done with that. And you're already seeing it, some of the motions to dismiss, for example, in the New York Times case, where on the defense side, there's an argument that, well, that search output was actually manipulated. And when you actually got the results, these paragraphs weren't all neatly lined up like that. They were very fragmented, and it's been reconstituted. And that's how you got what's in the complaint. And it's different from what you would have gotten in the organic search results from the AI. So I think we're going to have a lot of testimony about that, and really perhaps get into very granular analyses of these different copyrightable works as these cases play out.
So I wanted to close things out because I know Joey has a few messages to end with, but thank you so much to all the panelists. This was incredibly interesting and insightful. So thank you to everyone, and I'll send it over to Joey.
Well, Lindsay, thank you. And thank you, Claudia and Ekta and Louise, for such an amazing conversation today. I know our audience is going to walk away learning more than just one thing. So this was a fantastic event. I want to let everyone know that if you have colleagues or friends who you think would benefit from this event, it will be available on the ABA AI Task Force website starting Monday, April 29th. So we would encourage you to view it there. Additionally, I'd ask everyone attending to watch our calendar. We have 2 webinars coming up in May, one on the state of access to justice clinics and legal education and how it pertains to artificial intelligence, and another on the ethical limitations of AI when it comes to drafting documents. So we look forward to both of those events. And if you do have any additional questions for our panelists that you were not able to ask in today's event, you can always go ahead and email those directly to innovationcenter@americanbar.org, and we will make sure that our panelists have an opportunity to connect with you on those answers. Again, thank you everyone for so much for such an amazing event, And Lindsay, thank you for moderating. I hope everyone has a great day.
Thank you. Bye.
Thanks, everyone.